Let's start. Estate planning class one. So I'm doing two presentations. Class one is the basics. It's really for people who are new to Belgium, who haven't heard about inheritance tax, wills, bank accounts, etc. Just a general introduction, or for people who've been here for a while, a refresher. So let me introduce myself. My name is Mark Quagebuur. I'm a tax lawyer in Belgium and have been specializing for over 30 years in international taxation and cross-border estate planning. And Cabinet David is a law firm specialized in international taxation. I've been dealing with expatriates for over 30 years, and over these years I have gathered my knowledge and my experience and things we have come across with clients, expats in cross-border situations, and I've summarized that in a book, Rest in Peace, a guide to wills and inheritance tax in Belgium. We're already at the third edition, and we're working on the fourth edition, so that will be coming out sometime in 2021. We thought 2020 was not a good idea to have a book on wills and estate planning. So, what is estate planning? Well, most of you will say, well, it's a question of limiting the inheritance tax. Yes, that's it. And as a tax lawyer, that's what I'm doing most of the time. But it's much more than that. It is also a question of deciding who gets what. If you want your jewelry to go to your daughter and a painting to your son, you've got to make sure that that goes like that. It's also a question of taking out insurance to keep the assets in your estate, to keep them covered. And if your house burns down, you've got money to buy a new house. If you have young children, you may want to plan for them as well, appoint a guardian, find somebody who look after them when you're not there anymore. Well, usually that's not a problem, but sometimes accidents happen. Sometimes it's a way as well of ensuring that children do not inherit too soon. I had a client who had a certain amount of money, a large amount of money for each of his children. And he said, well, I don't want them to inherit the money too early. They've got to learn how to make a living for themselves. Some people have children who will need help in life because they're disadvantaged, because they have medical issues, or simply because they are disadvantaged compared to their brothers and sisters. In estate planning may also be a question of skipping a generation and give directly to your grandchildren. One of the rules that we use in estate planning is divide and rule. Divide your estate over as many people as possible and rule and save inheritance tax. Estate planning is also a question of diffusing family conflicts. If you want to have real conflicts in your family, tell one child that there's a secret bank account in Luxembourg, tell another that there's a safe in the basement, and another one there's a safe in the bank, and they'll be fighting for the rest of their lives. Estate planning is also a question of managing your affairs when you can't anymore, and then we're talking about lasting powers of attorney and living wills. We'll get to that in this next session. This session is mostly for people what I would call pre-empty nesters. You still have children at home, they are going to leave soon, or they're small children. This session is for pre-empty nesters. The next session is more for empty nesters. The children have gone, and now you have to decide what you're going to do. So estate planning never ends. It's a question of what is your situation. You're single, you have no assets yet, you're just waiting to build up your wealth, you stand to inherit from your parents. You're basically just growing older and becoming a prince and waiting for Prince Charming until you take over from the queen. You get into a relationship, and then you have other things to think about. You have to arrange for each other's future. You have to um, when you buy a house, the bank will insist on having health insurance, on life insurance to cover the balance due in case one of you dies, and there you are, you already have an estate plan. At that moment in time, there's probably not too much inheritance tax, so a lot of, if the risk of paying inheritance tax can be covered with an life insurance. You have children, and you have to think of the children. Have you appointed a guardian? Maybe take out life insurance. One of the things that is also interesting is if you are going to inherit, you could ask your parents to skip you, skip your generation, give directly to your children, or to put money in a trust fund to arrange for their education. That can be extremely efficient and tax efficient if your parents do not live in Belgium. We'll get back on that later. When in one third of all marriages end up in divorce, so that raises other questions. You don't want your ex to inherit from you anymore. When you're not divorced, you can still inherit from each other. And certainly, you do not want your ex to get at your assets via children. Your children inherit, and if they inherit, it also means that their the other parent, as their guardian, can have access to their wealth and has to manage their wealth. They could live in the house you're going to that you own, and you may not want that, so you have to take some precautions for that. And then, of course, you have a second relationship, and then you can get into tensions where you have a situation where you have children from a first marriage and you have mixed loyalties because you want to take care of your new partner and you cannot forget about your children. In Belgium, we have the forced heirship rules that oblige you to take care of your children. So you're not completely free to give what you want to who you want. So you grow older, you have grandchildren. You may want to set up yourself a trust fund for them. You want to spread your wealth over children and grandchildren in your will. And that is what estate planning is all about. And then you may have an ingracious daughter-in-law, a real diva. You don't get on with her, and then as she's an in-law, we call that in Flanders the cold side. You want to exclude the cold side so that he or she cannot inherit your wealth. And certainly that after a divorce, they don't get access to your wealth through the children as a guardian of the children. And then, of course, all relationships end when you're married or in a partnership. One of you will die first, so the other will have to think as a single again, with or without children, and then that raises other questions about wills and inheritance tax. Before we go further, let me just summarize what happens when you die. Now, you may not find that very interesting or it doesn't concern you, but it is important to know what your heirs will have to do just to get access to your wealth. Whether you die in a hospital or at home, the best thing for your beloved to do is to call a doctor who has to certify that you're dead, and a death certificate is then lodged with the commune. Now, the doctor will be able to advise, or the hospital will be able to advise a funeral undertaker to take care of everything. Um, Take a cool look. Well, if you're on the receiving side, when you have to deal with a funeral, take a cold look at the figures. Make sure you don't get taken advantage of under the stress of the death. Now, the death must be reported, and that's at the town hall of the place of death. So if you die in hospital in another commune, that's where the death certificate will be. Usually, the funeral undertaker will take care of that on your behalf. The commune will deliver death certificate, and you'll need that for your employer if you're still working, for pension funds, for social security, mutuelle, and banks. In the past, I used to say, well, get at least 10 copies. Now, these certificates, you only get one with a QR code so that you can, for a period of 6 months to a year, download a copy of these certificates and use them or send them by email to whoever needs to get them. And then you'll have heard about the banks blocking your accounts. You have to notify the next of kin have to notify the banks. There is no legal rule of when you have to do it. You just have to do it as soon as possible, as soon as practically possible, if you are abroad, it's not as easy as when you're here. And in these days, the banks are usually closed as well. It is true the bank accounts are frozen. That's the personal accounts of the deceased, but also joint accounts, and sometimes the account of the spouse. The reason is not because the bank has to do that by law. If you have children who live outside the European Economic Area, and from the 1st of January that will be in the UK as well, then they have to block the accounts until the inheritance tax is paid. But otherwise, the banks are just doing that to make sure that um, they give the money to the people who are entitled to it. It does not mean that you don't have access to money. The bank will pay hospital and medical bills if you give them to the bank. And they also allow the spouse or the civil partner or the registered partner to take up 5,000 euros or half of what's on the bank account, whichever is the lowest. The maximum is 5,000 euros. To release the bank account, what you need is a certificate of succession. The best thing to do is to um, go and see a notary with the death certificate and then evidence of who the heirs are, spouse and children. The children, if you're married in Belgium, will be registered in this certificate of in the carnet de mariage. Otherwise, you'll have to bring the birth certificate, etc. The notary will take a couple of weeks because he has to check whether there's any wills. There's a central register of wills where all the wills that have been made by a notary or that have been lodged by a notary are noted. There's not much information there, just that there is a will for this and that date with this notary. The Central Register of Wills gives you a full list of all the wills. In one case, I saw a lady who died at 96, and she had changed her will 30 times in the last 60 years. Now, the estate passes automatically in Belgium to the heirs. So as soon as you die, your heirs become the owners. There is no such thing as probate or an executor needed to make sure that the estate passes to your heirs. It goes automatically, and your question then is, how does that happen? Well, basically, the certificate of succession will be an official confirmation by the notary of who the heirs are, and that will be useful for the banks, for brokerage accounts, etc. It will also, and for the transfer of the real property, basically the heirs will have to file an inheritance tax return in which they list all the property. And when the inheritance tax is paid, the tax office will register the transfer of the property to your heirs in the cadastre and the CIN, that is basically our Belgian land register. Now, in some cases, you may be appointed as the legatee or be the heir of somebody, and knowing that there is not going to be anything, um, you may want to waive the inheritance. But in general, people accept the inheritance. But acceptance means that you take all responsibility for all the debts that are in the estate. Acceptance can be implicit by, for instance, if you take money from the bank account to pay for hospital bills and to take the 5,000 euros to cover certain expenses, that is an implicit acceptance, and it cannot get out of that. Waiving the inheritance must be explicit. That's by a statement before a notary saying, I'm refusing this inheritance, I don't want it. You can make um, an acceptance conditional, saying, well, I'll accept it if an inventory is made and if the inventory shows that the estate is, the value of the estate is positive. As I mentioned the inheritance tax return before, you'll see that the taxman sends a reminder. He's informed via the commune, of course, to say, well, don't forget to file your inheritance tax return. And in that case, the heirs have an obligation to file an inheritance tax return. Even if they don't get a reminder, that's their obligation. They take the inheritance, they have an obligation to declare what they have received. People say, but that's an obligation for the notary. That's just getting things wrong. The notary is just maybe in the driving seat, maybe preparing everything. But if you haven't declared anything, or if you forget to file an inheritance tax return, if you do not declare everything, if you omit to declare something, you're exposed to the inheritance tax and the penalties for not filing. In general, you have 4 months to file an inheritance tax return starting at a death. In these COVID times, there have been extensions of about 2 months, so you could file during 6 months. When you file, you have another 2 months to pay. In some situations where you have to find more information, you can get an extension to file for up to 6 months, but then you have to pay within the additional 2 months as well. In Flanders, they've changed the rules, they changed inheritance tax returns, and Flanders sent out a bill first, and then you have to pay that as soon as possible. Now, I told you you're pre-empty nesters, so what happens when you die? Well, if you have children under 18, the surviving parent is automatically the guardian. But if both parents die, then you need you need an official guardian. Now it's the justice of the peace who appoints the guardian. You cannot appoint him yourself, but you can make a list of wishes saying, "Well, I want to have so and so, my brother in Denmark or my sister in Greece, as the official guardian." Now, the justice of the peace may take interim measures and say, well, look, for the moment they stay with the parents of their friends. Um, they'll the justice of the peace will listen to your wishes or will take note of your wishes for the guardian and will usually abide with those, but he will also listen to the children. And if the children hate their aunt in Greece, then he'll probably try and find an alternative solution. In fact, he decides what's best for the children, even if you have made arrangements. The aunt in Greece may have gone mad and may not want the children, so he has all the freedom to decide. He usually appoints a guardian, but also a supervising guardian. In the past, there was a conseil de famille with three people from each family, the father's and the mother's family. Now that's much more simplified, but usually we'll have a guardian and a supervising guardian who will check that the guardian does his job properly. So, about inheriting. So, what questions we're going to see here is who inherits my estate? First of all, what is in my estate? Who inherits it? How much is the inheritance tax? How can I change this? And what planning can I do? So, some misunderstandings is that you say, well, everything that's in my name is mine. That may or may not be the case. That may depend on your marriage contract. People would instinctively say, well, my spouse, of course, because that's the way it happens at home in Ireland or in the UK. That's not necessarily the case here. The inheritance tax in the UK, there's no inheritance tax for spouses. You can opt for English law to govern your estate, but you cannot opt for English inheritance tax and the absence thereof between husband and wife. Why would you want to change this? Well, we'll give you some examples. And if you say you're too young for that, well, I hope that you will learn something from this presentation that will show you that it's never too late or too early. So what's in your estate? Well, of course, your personal property, but also half of the community property. And that is really raising the question of what is your matrimonial property regime? The matrimonial property regime is the regime that determines who owns what with a married couple. If you marry in Belgium, then and you live here in Belgium, then you have the default Belgian regime, which is community property. Everything is owned 50-50, except what you had before, but that will be before your marriage, and that may be an old table and a sofa, maybe a car that is now on the car graveyard. Usually you have everything 50-50. that's the question about the marriage contract, and the Belgian regime is the default in Belgium. Now, you can opt for separate properties either in a marriage contract, or if you're two Brits who married before 2004, Belgium will assume that then your matrimonial property regime is the English one, which is completely separate properties. Or if you married and lived in a common law country like the UK, Ireland, or the US, then in that situation you have separate properties. So if you have separate properties, in your estate is your personal property, and your spouse has their personal property. For instance, that could be you could have 10 and your spouse could have 90, which means that if your spouse dies before you, there will be a lot of inheritance tax to pay. But if you have 90 and he or she has 10, then there will not be a lot of inheritance tax to pay. But most people have very little from the beginning, and then when you have community property, each has half of the community property, and your half, when you die, is inherited by your heirs. So the 100 is divided more equally between the two spouses. So who inherits? Well, first of all, your children. That's all your children. I used to have a picture of Princess Delphine Boel in here, even if there have been acknowledged children inherit. And if one of your children has died before you, then his or her children, your grandchildren, will inherit their share. So we've got three children, one dies, and they have two children. Uh, so what the two children will inherit one third, and the grandchildren will inherit one sixth of your estate. If you have no children, then it's your parents and your siblings. If you don't have any parents or siblings, it's your uncles and aunts, and we can look for quite a while to find distance descendants of great aunts, or your grandparents and great grandparents. But in the end, if nobody is found, it's a Belgian state. So if you're single, you don't want anybody to inherit, and you don't want the Belgian state to inherit, you have to make a will. Now you'll say, what about my spouse? Well, the spouse, that depends. Until the 70s, the spouse didn't inherit. Everything was inherited by the children. But then we introduced rules for a surviving spouse. If the spouse inherits with the children, she has usufruit of your estate. I'll get back on that word. But basically, the children own everything, bear ownership. The spouse inherits usufruit. If she inherits or he inherits with other family members, basically your brother and your wife inherit, then she inherits half of the community property. So that means that everything that's community property goes to her, but she only inherits the usufruit of your personal property. Now, you may think that is a good idea. Your personal property goes to your family, but if you don't have community property, all she has is usufruit of your half of the family home, and in that case, there is not much to be inherited. That can be a poison chalice, and in fact, everything or your half of your family wealth will go to his or her family. Registered partners inherit only an usufruit of the family home and the content, so the furniture and the house, but only the right to live there. And a non-registered partner, you just live together but have not formalized anything, inherits nothing. So if you have a partner, or if you are a partner from somebody with some wealth, make sure that they make a will. It's not a guarantee. Will can always be undone, but at least uh, there is you are taken care of. Now, what is the usufruit? That in Belgium is a default solution for what the spouse inherits. It is both the use and the fruit. If you have usufruit of a house, you have the right to the rent, the right to live in it. If it's a bank account, you have the right to interest, to receive the interest. But that's often a poison chalice. If there's not enough money, you have to cover up the maintenance cost. of the house. If the roof has to be, it's only certain major costs that for which you can go to the bare owners, the other heirs, to ask them to chip in for the costs. And on bank accounts, of course, nowadays the interest rates are low. So on a million, you may get 10,000 euros. You can't live with that, but you cannot have access to you cannot sell or take the money itself. Same for shares and dividends. You cannot sell the shares, and you cannot, even if they crash, you can't sell them and reinvest them. So I would say avoid giving usufruct or avoid giving just usufruct. Make sure that there is enough to uh, take care of the livelihood of your spouse. As we'll see, not in this webinar, but the next one, usufruct can also be used for instance, a split purchase or to make gifts to the children and keep usufruct. Do you need a will? Well, if you want to change the default rules, for instance, you want your spouse to have more, and I would suggest that you make a will to give the family home to your partner because that's uh, tax efficient. There's no inheritance tax when your partner or spouse inherits the family home. It can be used for tax planning as well. You decide who gets what, who gets the painting, who gets the car. You can use to appoint a guardian to make funeral arrangements, make sure that I'm on the list of your invitees and have a good party. And if you give usufruct to your spouse, make sure that your children do not have the right to convert to usufruct, basically buy out your spouse or partner and tell them that they can't do it. It's also, you can also use a will to opt for your national law. Anybody who's not Belgian because of this other nationality, I'll get back to that in a minute, can opt for his own national law. If you're Japanese, you can choose for Japanese law to then govern your estate, and but not for you cannot use it to opt for Japanese inheritance tax. Now, there's different types of will. The simple one is you hand write it out in full, and to do that, all you need is a piece of paper, a good pen, and legible handwriting. The important thing is you need to sign it, put a date on it, and write it all in full out in your own handwriting. Those are the three conditions. Notarized will are wills where you go to the notary, say this is what I want. 2 weeks later, you go back and he says, this is what you have dictated to me. Please sign here, and there's two witnesses. An international will is basically a will that you can make in any language. You put it in an envelope, you tell the notary it's my will, and please take care of it. The notary will make a public deed and saying this is the will. I haven't read it, and these are two witnesses who have seen and heard this person say that this is his will. You can type out an international will and leave it with the notary. It will get registered in the central register of wills, unlike a handwritten will which you keep in a safe and which can get lost. If you have made a will in Greece before coming to Belgium, is that will valid? In principle, yes, it's valid, but it may need to be translated so that we can make sense of it in Belgium. It needs to be translated from Greek into Belgium, but then also from Greek law into Belgian law. There are limitations. So that's the forced heirship rules. The children must get 50% of the lifetime estate. That is what you have left at the end of your life, plus also anything that you have given away during your lifetime. So you can't give everything away and say, well, I've got not 100 euros left. Children get 50% of that. The spouse must get usufruct of half your estate or usufruct of the family home, whatever is the most advantageous. There is no protection for registered partners. Can you get around the forced heirship rules? Well, your will is governed by the law of your habitual residence. If you have made a will in England, that will be governed by Belgian law and the forced heirship rules. However, here is Europe intervening. We have the EU succession regulation that allows you to opt for your national law. If you're English, you opt for English law. If you're Scottish, you opt for Scottish law. And then you can get around the Belgian forced heirship rules. But that does not apply to inheritance tax. You cannot opt for English inheritance tax. Inheritance tax is Belgium, and you know that Belgium is a country with three regions: Brussels, Wallonia, and Flanders, and each have their own inheritance tax code. We all started with the same, um, but then they changed the rules, introduced separate rules. So depending on where you're living, you the rules of your region will apply. If you have moved recently, you have to move. You have to wait 2.5 years before the rules of the new region will apply. We look at the last 5 years, and it's the place where you lived longest that will apply which rules apply. Decide which rules apply. So inheritance tax. Well, if you're Belgian resident or non-resident, the rules are different. If you're Belgian residents, we'll look at your estate, your whole estate, in Belgium and abroad. And we also include life insurance. And that's something that surprises a lot of people. And gifts in the last 3 years, unless gift tax has been paid. If you're non-resident, um, inheritance tax is only due on the real property that you have in Belgium, and that also there's no inheritance tax on life insurance that you take out abroad as a resident abroad or on gifts that you make there. But there is no inheritance tax on gifts if gift tax has been paid on your state pension, on occasional pensions when they're inherited by the spouse, whether it's a lump sum or a monthly pension, as long as it's funded by an employer. So a self-employed pension that you set up is liable to inheritance tax. And the most important exemption is a family home that's inherited by your spouse or your registered partner. The inheritance tax, well, for the direct family, a spouse, registered partner, children, grandchildren, goes between 3 to 30%, 27% in Flanders. 30% is from about 500,000, 27% is for the over 250,000, and it's calculated in Flanders separately for real estate and movables. So a person with 4 children or a couple of 4 children can give up to 200,000 each to their children and pay only 3%. 200,000 movables, 200,000 real property. For brothers and sisters, I quickly go through the rates. It's 20 to 65%, 25 to 70, and friends and strangers, it can be quite a lot of money. So let me just give you an idea. You'll see here in Brussels, a spouse on 50,000 will pay 2.1%, on 500,000, an average of 16%. Children about the same, but non-relatives pay tax between 40 and 71%. I'll quickly skip this. You'll get this in the presentations later on. So let's have a look at specific situations. You come to Belgium, you're single. What does it mean for me? Well, you may think I'm an expat, so I'm exempt. Well, that doesn't really work. If you live here, you have your residence here, you've got your domicile here, and basically the Belgian inheritance rules apply. But you can opt out with the EU succession regulation, say, well, I want Greek law to apply. If you live here, Belgian inheritance tax will be due on your worldwide estate, including on property outside Belgium. Now, this expat has the benefit of the expatriate tax regime. Now, that is a regime where you consider to be non-resident for income tax purposes, but you are living in Belgium, and inheritance tax will be due if you've been here for a couple of years. In certain exceptional circumstances, if you die within 3 months of arriving here, and if your family goes back immediately, then one could argue that you haven't really meant to come to live in Belgium for the rest of your life, and that you haven't taken up residence here. If you're resident in Ireland and you only work here in the week, then you are only liable, inheritance tax is only liable, it's only due on Belgian property. Question is, how do you prove it? You will have received a Belgian ID card to live here during the week. So that may be more difficult. You will have to prove that you're non-resident. If you're non-resident, inheritance tax is due only on your Belgian real property. If you inherit from your parents in another country, then there's no Belgian inheritance tax, except of course if your dad had property, real property in Belgium, then inheritance tax is due, but that is rather unlikely. If you invite mom to come and spend her last years in Belgium, keep in mind that her estate will become liable to inheritance tax, whereas where she's living now, there would be no inheritance tax. There will be a Belgian inheritance tax. So make sure you plan before she comes, make gifts, and try to arrange things. I'll skip this one just for because we're running out of time. It's emergency planning. Um, EU officials, well, if you're recruited from another member state, for instance, you're Italian and you're recruited from Luxembourg, you will have your domicile in Luxembourg, even if you're Italian, but inheritance tax is due there in Luxembourg. But there will be Belgian inheritance tax on the house or department you have in Belgium. So that can or cannot be interesting. On the other hand, if you're recruited from Belgium, you're fully domiciled and resident here, and Belgian inheritance tax is due on your entire estate. The situation is different for a spouse. If his spouse is a stay-at-home dad, or if he has a career of his own, if he's a stay-at-home dad, he has the same domicile as his partner, as his spouse. The EU doesn't recognize partners yet. But if you have a career of your own, your domicile becomes Belgium, and then Belgian inheritance tax is due on your worldwide estate, even on overseas properties. Now, you've been here, you found somebody to share your life. If you haven't got children yet, keep in mind that your spouse will inherit half of the community property, and if you have no children yet, usufruit of your personal property. That means that your personal property, and for people who have separate properties and no community property, that means everything. So you have he or she has usufruit of your half of the house, but then it will go to his family. Now that's okay for the family inheritance. You want that to go back to the family, but do you want that also to happen to the family home? You or your partner might be quite annoyed to find out that you have to share your house with the family of your spouse. Solution there is make a will, but then you may not want to do that because you give your the family home to your spouse, and you are in fact disinheriting your own family, your brother and sister, nieces and nephews. The home will go to her family in that case. The solution there is make a bequest in cascade. First, you leave everything to your spouse, and what's left is then going back to your own family. And it goes to your family not from your spouse, who is a complete stranger and on whose estate inheritance tax is due at rates of up to 80%, but at the rates for brothers and sisters because it comes originally from you. If you're thinking of going home in 5 years and you do not want to take the risk of having to pay inheritance tax, a cheap solution may be to take out life insurance to cover the Belgian inheritance tax. Make an estimate of how much the tax will be and take out life insurance on about to cover about 1,500,000 if you're in your mid 50s. The premium would be about 2,000, 2,500 per year. Do not take out insurance on your own life because then that insured capital becomes liable to inheritance tax. Have your partner take it out on your life, and you take it out on his or her life. If you um, if you are married and have children, agree together who will be the guardian. Have insurance to cover the mortgage and to provide for the family. And do not forget that your registered partner only inherits usufruit of the family home. So make a will, because that can be a poison chalice. So make a will, appoint a guardian, make sure that you leave the family home to your spouse or partner. That's free of inheritance tax, but make a bequest in cascade saying basically, you have my half of the family home, but when you die, I want it to go to the children as if it came from half for half from each of us, which is basically a way of saving the inheritance tax that will be due upon the second death. In that case, the children inherit from two parents and they will pay less inheritance tax. If you have parents outside Belgium, you can ask them to help you with their will and make a bequest in cascade. First, they make the will in your favor, but then when you die, the inheritance goes from you to your children, not from you to your children, it goes from the grandparents to your children. That means that there will be no Belgian inheritance tax when you die, because basically your children are deemed to inherit not from you, but from their grandparents. If they're planning to make gifts of property, again, ask them to do the same thing, make a gift in cascade first for you and then for your children. In particular, that's important for overseas property, and that means that there's no Belgian inheritance tax you die, and there is also no Belgian gift tax. If you have overseas property, there may be that may be not liable to inheritance tax there either, because it's a country that does not have inheritance tax, or a country that doesn't charge inheritance tax between husband and wife. So then you don't pay inheritance tax there, but there will be Belgian inheritance tax. How do you solve that? Well, there are ways of shifting the inheritance tax to the children with an IOU. That means that in your will you say, well, I leave the family the property in France to my wife, but when she has to agree to owe the half the value of it to each of my children, and then the children pay inheritance tax on the IOU, and the IOU is deducted from the value of your estate. Um, I'll just go quickly through these because we're getting close to time, and I'm sure you want to ask some questions. Um, the forced heirship rules protect children from, as I said before, from a first relationship, and they limit what you can give to your spouse. So if you want to give more to your spouse, an option is to opt to your national law, or you can leave your estate to your spouse by opting for a marriage contract with community property, and in that contract say that the or in the marriage contract say that your spouse will owe an amount of money to your children for the rest of her life, and she won't have to pay interest on that IOU because she's got usufruit. So I think we're getting to, or just one thing, if you have stepchildren, they do not inherit from you. You have to make a will to make them inherit from you. The good thing is that in most regions, the stepchildren pay the same tax as inheritance tax as the children, at least if the parents are, the parent and step parent are married or at least registered partners. So I'm getting to the end of my presentation, and now you've got the questions here. We'll try and deal with the questions